My thesis is on decision-making at coroner's inquests in Peterborough during the 19th century. Quick content note, I will be briefly discussing suicide and traumatic death. Local archives are sometimes discussed with a kind of disdain, as though the only worthwhile material is stored by our friends at the National Archive, at the British Library, or in other major institutions. However, I have solely used local archive material in my thesis. And I do mean local. Peterborough Archives Reading Room is one room in the Central Library, and this is it. This is all you get. It's only open 4 days a week. The technology is elderly, the council are stingy, and the major business is checking planning permission and electoral registers. But in this unassuming room, I have found astonishing treasure, not least the staff. My thesis grew from my MA project, and my MA project took off because of the local archive staff. I did my MA with the Open University, and the dissertation was a local history project. Like about 80% of the cohort, I wanted to do something on the workhouse, specifically the experience of illegitimacy. So I naively trotted off to my local archive and I asked if they had the workhouse records. They didn't. The workhouse records were in Northampton Archive. Peterborough is a unitary authority now, but it used to be within Northamptonshire, and Northampton retained most of the city records. I was disappointed because I didn't have the wherewithal to travel to Northampton at that point, so I asked them offhandedly if they had the inquest records. Now, I knew about inquests because I started out as a family historian. I'd used inquests from the press countless times and simply assumed the records would have been kept. It was absolutely unthinkable to me as a baby researcher that records around these important events would not have been kept. When I asked for the inquest records, I had no idea that what I was asking for is vanishingly rare. So I had no idea when they replied saying that they had a full run from 1844 that this was such treasure. I actually had no idea until I was doing my lit review and realised there's hardly anything on the 19th century coroner. This is an example of what you might find in a 19th century inquest if you're lucky enough to find one. This particular example is from 1856. This is the verdict, the legally binding bit, which stated the cause of death. This bit on the bottom is where the jury signed and sealed their decision. This is a nice little rarity. It's a warrant for a medical examination. These don't survive very often. This is the warrant that was used to summon each juror. Most of the official paperwork was written on pre-printed stationery, and my co-panelist Helen has found similar examples in Newcastle and Durham. This is the list of witnesses and jurymen to be called to the place of inquest, and these are the actual depositions folded up. When they're unfolded, they look a bit like this. If the coroner found a criminal verdict, the verdict was written on parchment rather than paper. This is an example from 1857. The depositions, the sworn witness statements, were handwritten, usually by the coroner himself, and they were signed. They're not always very legible. But there are other treasures to be found in these files. This is a letter ordering the removal of a sick man to the workhouse, complete with a tiny envelope. He died on arrival, hence its inclusion. And sometimes I find suicide notes. This is Eliza Wilson's scribbled note. You can see how it's been torn out of a small notepad. The paper's actually pink and it's really, really small. It's only about 3 or 4 centimetres high. Nothing actually affects me quite like finding this kind of original documentation. It's an immediate and tactile link to the past and a reminder that these people really lived and really died. The 19th century coroner, as I will demonstrate shortly, was a law unto himself. There were few rules governing his conduct and no rules governing his data retention. The records belonged to the coroner to dispose of as how he wished. One of the Peterborough coroners in the 1940s assembled all the records he could find from 1807 to 1830 and gave them to the local pathologist at the hospital who was interested in the history of the office. After the pathologist died, his son found them in his house, gave them to a local history group who didn't know what to do with them, and they eventually found their way to the local archive in 2 batches, one in 2005 and one in 2014. The main paperwork the Victorian coroner was expected to supply was the legally binding inquest verdict and an annual return to the Home Office detailing the year's business. Nobody ever saw these verdicts unless they were criminal when they were sent with the depositions to the assize, and yet inquests could clearly generate enormous amounts of paperwork. This is one box of inquests covering 4 years. Peterborough holds 20 boxes covering 50 years, and Peterborough's Victorian coroners held very few inquests, 20 to 30 per year. In a city like Liverpool, which had closer to 1,000 inquests per year, the paperwork built up. So it's not overly surprising that after a suitable amount of time had passed, these records were burnt, thrown away, or whittled down to just the verdict. Another issue was jurisdiction. The English coroner has early medieval roots. In Peterborough, a city of 10,000 souls in 1841, there were 4 coronial jurisdictions, all pre-Reformation. You can see them on this map. The Liberty of Nassaburg was much bigger than it seems here. It stretches all the way to Welland, which is about 8 miles north. In practice, 2 men covered this whole area for much of the 19th century, and we know that this made a practical difference to record retention because the coroners of the Liberty of Nassaburg City and Minster kept their records. The coroner for Norman Cross lived in Peterborough, and he worked with his Peterborough counterparts regularly in various legal capacities, but he didn't keep his records. The third issue is, as I've mentioned, storage. Peterborough Archive hold this collection of inquests now, but until 2015 they were held at Northampton County Archive. We're not quite sure why Northampton offered the records to Peterborough, but after speaking to Jessamy Carlson at the National Archive, I believe it was to do with a change in the Public Records Act. In 2015, a variety of records, including those from the NHS and coroner, required archival deposit after 20 years. Previously, it had been 30 years. This meant the arrival in every county archive of a glut of new records to sort and store. Northampton don't seem to have valued their trove of coroner records. They arrived in Peterborough virtually untouched since their acquisition 50 years earlier, catalogued incompletely, with no apparent recognition of what the inquests actually held. If Peterborough had not accepted them, it's possible they would have been culled down to just the verdict sheets. Local archives will take what bigger archives do not want, and what bigger archives want is changeable, influenced by contemporary trends as well as shifting policy. The surviving coroner rolls for the 14th century are treasured objects at the National Archive. The inquests done in a provincial town in 1880 are less interesting. Archives are in a constant state of acquisition and cataloguing. Space is always an issue. However, redistribution of records between county and local level is unusual. Peterborough came to have these inquests by a happy fortuitous accident. So why are they useful? After all, inquests are routinely reported in the press, and there are many histories of the coroner written using these as sources, alongside legal and parliamentary sources. 19th century coroner history is rather patchy. There's a body of work on Thomas Wakeley and the push for medicalisation. Thanks to my co-panellist Helen, you can read about how coroners interpreted the law outside of London. There are numerous social histories using inquests as a source, including work by Vic Bailey, Elizabeth Hurren and Vicky Holmes. But there's very little information available on how the coroner's court worked in practice and how it tied into the wider legal system. The coroner is barely mentioned in existing work on homicide prosecution, despite being a key early element of the process. The legal framework for the coroner in the 19th century was tremendously confusing, spread across multiple acts of parliament, some dating back to the 1750s. It was also in a state of flux, as the state was lobbied to either abolish or professionalise the role of coroner. To keep coroners abreast of all relevant law and any changes, Sir John Jervis published a book distilling law into best practice in 1829. This book, much revised, is still in use, currently in its 14th edition, I believe. But such were the rapid changes in coroner law in the 1800s that it went through 5 editions by 1888. Some of the existing literature on coroner manuals assumes that they were followed verbatim, that they were incredibly influential in developing coroner practice, and that this slim 280-page volume was regarded as a Bible, a book of absolutes. It wasn't. It was more a set of guidelines. Take jury selection, for example. There was no property or financial criteria to meet for coroners' juries. Instead, they had to be men. That's very important. They had to be non-felonious. They had to be able to write their name on the Inquisition, and they had to be good and lawful, however you define that. They were supposed to have no interest in the case, and they were supposed to win a year off from service after appearing on a jury. There were also 2 pages of exemptions from jury service in this particular edition of Jervis, including vicars, professionals, local government, solicitors, military men, and anyone employed in medicine. Jurymen are hard to find. Their names are not often reported in the newspaper unless the case is very sensational. This is the jury list following the 1861 Clayton tunnel disaster near Brighton, which killed 23 people. Handily, their occupation and residence is included, which gives a little insight into the jury composition. Every juryman had to sign their names on every inquest verdict with a little seal. This is an example from Peterborough. So I analysed 106 of these juries across 50 years, which was 784 individuals, and I discovered something interesting. Almost all the exemptions and qualifications cited in Jervis were routinely ignored. The jurors were always men. The first female inquest juror sat in 1933, and I'm reasonably sure they were all non-felonious, but everything else, no. Illiterate jurors sat all the time. Their ex-signature was signed off by the coroner. You can see that here on a verdict from 1857, but I found illiterate jurors sitting as late as 1891. Jury service did not seem to win jurists any reprieve from sitting. 178 men sat on more than one jury within a calendar year. And when a woman dropped dead in a pub she was lodging in 1871, the landlord of that pub was on the inquest jury. He could hardly claim to have no interest in the case. When the hanged body of a man was found in Longthorpe Woods in 1880, the Reverend Arthur Charles Scrimshire was the jury foreman, despite being explicitly barred, according to the 1870 Juror Act. So we know what coroners should be doing from Jervis, but a detailed examination of the jury lists, one relatively small aspect of the coroner's court, shows that the coroners ignored these guidelines regularly. In my thesis, I argue that a strategic choice of jurors ensured that the verdict returned was the verdict the coroner wanted, but this is not an argument I would be able to make without knowing who the jurors were. This is the newspaper report of the death of Emmeline Laura Southwell, who died from a laudanum overdose in February 1859. It gives you the basic gist. Emmeline's mother sent out for Godfrey's cordial and was sold laudanum by mistake. Baby Emmeline died and the shopkeeper was arrested for manslaughter. The coroner's jury left a rider bemoaning the use of opiates in small children and the fact that small shops were allowed to sell laudanum at all. Surely, you would think, there can't be much more to this tragic story. This is one sheet of the depositions at Emmeline's inquest. One sheet of 14. Because what the newspaper doesn't tell you is that Emmeline's 3-year-old brother purchased the laudanum. It doesn't tell you that Emmeline's mother struggled for 14 hours to keep her daughter alive. It doesn't tell you that Robert Cook, the shopkeeper, was actually a cabinet maker. He was covering the shop for his wife, which is probably why the mistake was made. It doesn't tell you that he was distracted by other customers when the poison was sold, or that he spent all day at the Southwells' house as if his presence could save the baby. Sometimes the newspapers report everything from an inquest verbatim. Sometimes they do not. Sarah Bottom died in 1882, and the newspaper had this to say. No details, just a sudden and painful death. Sarah's death was horrendous and had a very, very clear mechanism. In the process of delivering the placenta after her baby was born, the midwives pulled her whole uterus out, and she died on the spot. The inquest was a prolonged inquiry into whether she died by medical negligence, and although the Peterborough Standard published quite a lot of detail, the Peterborough Advertiser was rather more prudish. And this is one of the great privileges of having such a great source to work with. You get the full story, you don't have to rely on the press. Sometimes you can even find examples of the coroner attempting to influence legal process. Elizabeth Wigington was a rich, well-connected widow in the village of Glinton. In 1857, she unexpectedly gave birth to a child when she was drunk, hid it in a cupboard and acted like nothing had happened. The baby was found by a servant, and after quite a bit of prevarication, the coroner was informed and an inquest was held. The inquest returned an indictment for concealment of birth, something I'm not absolutely sure he had the power to do, and the case went into the legal system. But among the notes in the inquest file was this letter, written to persons unknown by the coroner. I think it was sent to the Liberty prosecutor, as Elizabeth was initially tried in Peterborough. It says, "My dear sir, I have since the inquest been told that not half the truth came out from the governess and servant. She was in a state of insensibility, not merely from the beer, but from laudanum, either taken with or in it. I know the children are very nice children. The paramour returned after the inquest, and the wretched woman avows her intention of marrying him if he will have her. It would be a great mercy to lock her up in a jail for a 12-month, and I hope you will do the best you can for her and for her children. Yours very truly, Will Hopkinson." In the event, Elizabeth spent just 3 months in jail, but these additional notes demonstrate how much was going on in the background of the coroner's court. They show that this court was not just a formality, a place where people gathered to nod a murder or a strange natural death or an accident through the process. These deaths were interrogated at length and judged by people who were intimately acquainted with the circumstances. Any suspicious death in the 19th century was initially publicly aired in the incredibly localised coroner's court. The inquest had to be heard in the parish of death among the community. All 3 of these inquests that I've talked about were held in pubs very close to where each death occurred. All the neighbours could attend, and the jury may well have known the deceased and or the suspects. The coroner might be sympathetic, as with Elizabeth Wigington, and attempt to influence trial outcomes. The coroner's jury could and did express their concern or condemnation with common practices like giving babies Godfrey's cordial, and these condemnations would be broadcast in the local press. So it's fitting that these records are held in a local archive, in the same streets where these people lived and died, because all justice history in the 19th century starts locally. And now I'll pass you to Helen, who is also a very big fan of local archives and coroners.
So thanks very much, Sophie. Good morning. I'm delighted to be asked to speak today at this event because local archives are the lifeblood of my research, and without them, I wouldn't have had such an interesting academic career for the last 10 years. In my presentation, I'm going to outline how I use local archives in my research and my teaching, and finally, I'm going to offer some tips and advice from my experience. Sophie and I hope our papers today will inspire you to visit your local archives if you haven't been already, to find out what they can offer for legal historians. But first, I want to just give you a little bit of background for context to help you understand how I ended up in my local archives. I came to my academic career via a non-linear route. I have a law degree, and for many years I was a solicitor in private practice, handling clinical negligence and personal injury claims. Whilst working as a solicitor, I completed a master's degree in North East history at Newcastle University, and eventually I found myself lecturing in law at Northumbria, with an expectation that I would carry out research as part of my contract, but no real idea what I wanted to do. So one evening, the Law Society Social Committee organised a trip to the Victoria Tunnel, a subterranean wagonway which transported coal from a colliery inland to ships on the quayside. There's a picture of it on the slide. In the pitch-black tunnel, to the rumbling of a coal truck, the guide told the tale of a fatal accident and the subsequent inquest held by a deputy coroner called Hoyle. I knew nothing of Hoyle despite my MA, and very little about Victorian coroners. So, as all good researchers do, I googled the coroner's name, and this image appeared of a painting in the stores of the Lang Art Gallery in Newcastle. It's an image of John Theodore Hoyle, coroner of Newcastle upon Tyne from 1857 to 1885. I practiced in the coroner's court, and I had a general knowledge of 19th century history, so my interest was piqued. I soon realised that Hoyle, a pivotal character in the Victorian community, had disappeared from the history of the North East. So I became, and this is probably not too strong a word, obsessed, and 5 years later I had a PhD thesis. Thus this painting inspired my subsequent research career, both on Hoyle and on 19th century coroners, and it was the spark for the exploration of wider 19th century legal history. Because, as I'm sure you're aware, legal history is not only found in documents. The jigsaw pieces to answer your research questions can be scattered widely. So my first piece of advice is to think about archives broadly, not just the paper-based repository. Visit your local museums, libraries and galleries, and graveyards, because you never know what you might find that will lead to or contribute to your research project. This slide shows some images of some items I've used in my research. There's a sword in the Lang Art Gallery, which I established was presented to the coroner. There's his Hoyle's grave marker in St Andrew's Cemetery, some drawings from the early 19th century Durham Assizes by a French artist, Joseph Bouet, and a flask in the shape of Lord Brougham from the Discovery Museum. And this leads into a slight detour into methodology. You may have to borrow from different approaches and disciplines to develop a legal history project. My research uses methodologies from biography, local history, microhistory, art history, social history, family history, and material culture, and more, all used to explore legal history. For example, my work on the coroner is grounded in legal biography, which Vicky and Philip will be talking about later. When investigating legal history, keep an open mind and don't be afraid of the intersection with family history and local history, as I think Sophie's demonstrated. These approaches are often looked down upon by some academics, but snobbery is misplaced. Invariably, by starting locally, the national and the international picture come into clearer focus. Local history is not second best to national history. It's immensely rewarding and offers many opportunities to share your research outside of academia. By seeking to understand individuals within their communities, a rich picture emerges. As Sophie has noted, most legal problems start locally. And to find out how justice operated in communities outside of London, it's unwise to generalise about what happened from a London-centric study. When researching coroners, the only certainty is that each coroner and his practice was different from the next, and therefore exploring the local working of the inquest is paramount. So you must look at the local records and develop a site-specific picture. I'm not advocating for local archives to be used in isolation because repositories often intersect with each other. I'm not as lucky as Sophie. I don't have a lovely set of inquest papers for Newcastle. So I've had to search for my sources and triangulate material in assize files in the National Archives with accounts in Newcastle newspapers, correspondence, and other records I've been able to find. To write legal history from local archives, you must put on your detective garb. You must think laterally, you must pull threads, and you must explore. Think about what a local archive is and where the sources may be hiding. For example, the records for Newcastle are split amongst 3 archives: Durham, now called the Story, Tyne and Wear Archives, and Northumberland Archives, and I've found information in all 3. But I also found material in Durham University Palace Green Library, Newcastle University Special Collections, Newcastle Mansion House, Newcastle Law Society Holdings, the Literary and Philosophical Society, the Mining Institute, and more. And all of these can be broadly classified as local archives. So my advice, again underlining what Sophie has said, is speak to the archivists. They have an unrivaled knowledge of their collections beyond what is in the sometimes short description in the online catalogue. Some of the databases can be frustrating and the cataloguing can be eccentric. For example, I once found a tantalising reference in the description of a bundle of council papers to Dead House records, and I eagerly awaited the folder. And then I discovered the reference was to one line on one page. And of course, not all material is catalogued, and nor is it catalogued digitally. The archivist may know of yet to be listed items or obscure paper catalogues, and will keep an eye out for things for you if they know what your interests are. Sometimes where items are kept is a quirk of history. For example, I would find it extremely helpful if the assize files for the North East were stored locally rather than nationally, but because the local assizes were held by judges sent out from the senior court in London, the papers are stored in the capital. You are unlikely to find any assize papers in your local archive, although you might. However, there are many other sources. The slide shows examples of documents that may be stored in your local archive, and many are underused by legal historians. You might find quarter session papers and police court records, watch committee records, jail records, diaries, and a source that doesn't seem to have been widely used, solicitors' letter books. I'm now going to illustrate what the archivist can do for you with an example from my research. When writing about the life and work of John Theodore Hoyle, I discovered that the firm he founded had eventually become part of Richmond's. In the Tyne and Wear archive catalogue was this short entry, ACC 62 Richmond Solicitors. I wondered whether this deposit might contain information for my research, so I asked the archivist if I could have a look. The archivist recalled that she had perhaps seen the name Hoyle on one of the boxes, so I waited nervously for a few weeks. Eventually, the archivist emailed to tell me there were 7 volumes and 13 boxes of records, but enticingly, one box was labelled Hoyle Family Papers 1650 to 1914. I waited, and then I received this email, which told me that it might not be straightforward because the collection was stored in such a way that it made access problematical. I replied that I was willing to crawl around and get dirty, and then I got another email that just said I've not seen boxes like it. So I said I was even more intrigued, and I waited nervously again until eventually, when it was becoming unbearable, they said that I could have a look at the box, and this is the box. I opened the top, and this image of my coroner appeared. But also in the box was a diary, family papers, certificates of qualifications, materials about a court case which led to a precedent in the law of contract, plus much more. This material became an integral part of my research. Now, I can't claim to have discovered the contents of the box. Somebody deposited it and it was given a reference number and stored, but identifying what it was and its significance was a partnership between the archive staff and me. And of course, no one except me would have been remotely interested in what appears to be a random box of papers. And the joy doesn't end there. I've had a recent addition to this story. About a fortnight ago, I visited the archive in Durham to see an item described as scrapbook containing letters and newspaper cuttings concerning the work of coroners 1844 to 1867. When it arrived, I realised that the description does not reflect precisely what this book is. Yes, it's a scrapbook, but it was compiled by J.T. Hoyle, my coroner. It contains an insight into the work and preoccupations of a 19th century borough coroner, including newspaper clippings on coronial law, a letter from a coroner asking for advice, his handwritten appointment as a deputy in 1844, and a printed copy of a letter about an infanticide scandal, which I knew about, but had only seen the sections published in the newspaper. I'm compiling a collection of primary sources on the coroner for Routledge, and this book felt like direct help from the 19th century. So my advice is always check the miscellaneous files. Your specialist knowledge may identify diamonds where someone else has only seen glass. To move on from inquests briefly, my research, which started with the coroner, has led to work on trials, executions, victims, forensics, prisons and policing. I often write and present with my friend and colleague Claire, and I recommend visiting a local archive with a similarly invested colleague so you can share the finds with someone equally excited about the research and not bore your friends and family. We maintain close links with the archive staff, and our local archives research has led to articles, public-facing talks and exhibitions, and assisting with television programmes such as A House Through Time. And now just a quick word on teaching. One of the most rewarding teaching experiences I have had recently was using the local archives with law students and history students as inspiration for legal history dissertations and for a year-long project called A Public Spectacle, Murder and the Law in 19th Century Newcastle. By exploring in depth an 1875 murder and trial, the students gained hand-on primary research experience and developed their own relationships with the archivists who are an essential part of the project. The Public Spectacle project was supported by the National Archives, where we viewed the assize records, and then the students took part in training in Tyne and Wear and carried out further research there. They developed myriad skills which led to an exhibition, dissertations, blogs, a film, a painting, and more. The primary research and experiential learning inspired wonderful, deep and rich work. And the law students in particular were brilliant and embraced the project with enthusiasm, producing much more than they needed to do to pass the module. Sadly, I don't have time to go into this today, but the video, which was one of the outputs, is linked on the slide, and I'd be delighted to send you that link if you'd like to see it. As I come to the end of my 15 minutes, I hope I've given you a taste of the joys and the importance of local archives, and I want to end with some tips and conclusions. Tip 1 is get to know the archivists. They're wonderful people. They make your life so much easier with their local knowledge and experience of their collections. Be curious. Step out of your comfort zone and explore. Be persistent. Survival of documents is often luck, especially in local archives where random diaries and collections of papers can be deposited by families. And remember, there are archives in places other than the county repository. Keep meticulous notes, because the more you research, the more names and places you recognise to help you fit the pieces of the puzzles together. And linked to that thought is that you must follow names in the census and other records, and use newspapers. They're full of clues. And in the 19th century, full of surprisingly detailed reports of legal cases, from murders to proceedings in the Chancery Court. A name may lead you to a diary or an entry in an almanac or a hidden story. Find out about old county or borough or district boundaries to help you locate your field of search. Think about where the records might be kept. Explore beyond paper-based sources to enrich your research. So I'm nearly out of time, so I'm just going to offer you a very quick conclusion. The legal history of much of the country is unexplored by academics. What we have at the moment is a jigsaw with missing pieces. You are very likely to hit upon something novel if you start locally. London gets too much attention. although I appreciate that for some of you, London may be your local archives, and if so, see what there is beyond the National Archives. Most importantly, using local archives is a way to really get stuck into research and enjoy the process. It's immensely rewarding, and you never know what you might find. In my case, I found my academic career. Thank you.